Welcome to a bite-sized HIPAA case study, where I'll break down a real case of a HIPAA enforcement action at a dental office to see what we can learn and apply in your office. Today we're going to look at an interesting case study involving a single doctor dental practice in Las Vegas. This practice found itself on the radar of the Department of Health and Human Services in 2021 because of a patient complaint about not getting prompt access to her chart. Here's what happened. On April 11, 2020, a patient emailed the office asking for access to her and her minor child's PHI. 3 days later, the office replied, explaining that the office was closed right now, but offered to email the requested PHI to her if she confirmed her email address. By May 4th, the patient had confirmed her email, but somehow the ball was dropped and the information wasn't sent. After several additional requests, the office then asked her to submit a written request with her handwritten signature. The patient complied on December 4th, and then finally on December 31st, she received the information. HHS investigated the complaint, and they concluded that the dental practice failed to provide timely access to PHI pursuant to Section 164.524B. The result? The practice agreed to a resolution agreement, including a $25,000 payment and a commitment to improving their policies, procedures, and staff training on responding to patient access requests. The right of patients to access their medical records has been a hot topic of enforcement lately, with HHS cracking down on 41 cases related to this very issue. It's clear they mean business. So let's review the requirements to make sure that your practice doesn't find itself in the crosshairs. Under Section 164.524, patients have a broad right to access the data that providers have about them, except in a few specific circumstances. These exceptions include personal notes from a mental health session, information compiled for legal defense, data from a clinical trial, and instances where sharing the information could cause harm. Outside of these exceptions, practices must provide prompt access to the data in the form the patient requests. Access must be provided within 30 days after receiving the request, unless that's not feasible, and then an extension of 30 more days is available, but only if the patient is notified. Practices may charge a reasonable fee for producing the data, but that fee must be directly connected to the actual cost of responding to the request. Practices may require individuals to make requests for access in writing, but only if they inform the individual of this requirement beforehand. Practices are allowed to require individuals to provide proof of their identity before granting access to their PHI. And then finally, the law also provides the detailed steps to take if denying a request. So what went wrong in this case? Well, when the request came in on April 11th, there wasn't any apparent reason to deny access. It was a good idea for the practice to request the patient confirm their email address for security purposes. But after that email, they were on the clock to respond. They had 30 days to comply, a window that they unfortunately missed without notifying the patient of any reason for the delay. Now, we don't know when they asked for a signed written request, but it seems likely it was already past the 30-day window. This requirement would have been permissible if the practice had informed her when she first made the request, but not after already responding to her email and agreeing to send the data. In the end, it took over 8 months to provide this patient with access to her data, which was clearly unacceptable to HHS. I want to give the practice the benefit of the doubt here. I'm sure there was no malice and the requests just fell through the cracks in a busy small practice. But if they had had adequate procedures in place for handling access requests and thorough training on those procedures, they could have saved $25,000 and a whole lot of headache. We address this topic in much more detail in Bite-Size HIPAA, including a comprehensive procedure that will help your staff ensure that they are fully complying with the law when handling PHI disclosure requests. If you haven't made HIPAA a priority yet, start today. Join our online HIPAA community for dentists at bitesizehipaa.com. Explore and learn for 60 days on us. Please watch every training course, we call them Bites, and explore the tools that we've created to help ease HIPAA implementation and compliance. There's no risk. Give us a little bit of your time, and we will teach you about the HIPAA law, why it exists, and how, if done right, you can protect your patients and your practice from a variety of very real threats that inherently exist in today's dentistry.